Trial procedures. Several steps may be taken before a civil action moves into a trial court, often referred to as the court of record, oftentimes a bar. For example, the clerk of the court typically makes a calendar call, reading out the list of cases on the docket to determine whether the case is ready for trial, or if not, to set a trial date. A trial may be divided into several parts so that separate but related issues receive an equally unbiased hearing. A bifurcated trial is a trial that has been divided into two separate hearings, depending on the type of case involved. One hearing may, for example, center on the defendant's liability. The other may focus on the defendant's mental competence. Before trial begins in court, a proceeding known as pretrial hearing or pretrial conference is often held. During such a hearing, counsel for both sides and the judge seek ways to simplify and accelerate the trial process and to see if the parties are able to reach a settlement without having to go to trial. Options for achieving this goal include simplifying the pleadings, obtaining the necessary stipulations to avoid lengthy discovery tactics, and narrowing the number of witnesses to be called. Only the lawyers for each side are required to attend a pretrial hearing, but many attorneys choose to bring their clients in case questions arise. A report of the hearing becomes a part of the official case record, a precise account of all verbal and written proceedings in an action. Selecting a jury. In all criminal cases and in civil cases involving financial loss or injury exceeding $20, the United States Constitution guarantees the right to a trial by jury. A jury is a group of people known individually as jurors, who are sworn to determine the truth in a case. Such a trial is known a trial by jury or jury trial. The jury charged with deciding a civil or criminal case is typically composed of 12. Technically, such a jury is known as a petit jury or a trial jury. By contrast, a grand jury is a people of between 6 and 23 jurors, depending on the jurisdiction, charged with determining whether sufficient grounds exist to warrant a formal criminal charge known as an indictment, also referred to as a true bill. The grand jury hears preliminary evidence from the prosecutor and determines whether sufficient evidence exists to charge the suspects with a crime. In making this determination, the grand jury has broad investigative powers, which include the ability to subpoena witnesses and evidence. An indictment will be issued if the grand jury determines that probable cause exists, that is, whether it's more likely than not that the particular suspect has committed a particular crime. Under the rules of civil procedure, any party may demand a jury trial within 10 days of service of the last pleading in the action. Otherwise, the matter must be resolved by a trial without a jury known as a jury-waived trial or bench trial or a trial by the court. Regardless of whether the trial is heard before a jury or only before the court, the presiding judge is known as the trial judge. The specific procedures involved in choosing a jury vary from state to state, though the basic process outlined below applies to most states. Prospective jury members, or jurors, are typically selected at random from information collected by a state agency, such as a voter registration or the Department of Motor Vehicles. For each case, the large pool of prospective jurors is narrowed down to a smaller pool, typically referred to as the jury panel or veneer, or less commonly as an array. When jury selection begins, the clerk of court places each juror's name on a ballot and puts it in a ballot box. The members of the veneer are brought into open court, and 12 names are chosen at random from the ballot box. The 12 people selected take seats in the jury box and briefly interviewed by the attorneys. This interview is referred to as a voir dire examination. It serves to determine whether a prospective juror is impartial, that is, capable of making a decision based solely on the evidence. Attorneys from either side of the dispute may challenge or request the removal of prospective members of the jury. Two different kinds of challenges are available. First, a challenge for cause is submitted when the attorney believes a prospective juror fails to demonstrate impartiality. The second, a peremptory challenge, requires no specific reason to be given for the removal of a juror. An attorney may theoretically submit an unlimited number of challenges for cause. The number of peremptory challenges allowed depends on the type of action. In a capital criminal action, one in which the death penalty may be inflicted, attorneys for each side are allowed a number of peremptory challenges equal to the number of jurors to be selected. In both non-capital criminal and civil cases, lawyers for each side are entitled to 4 peremptory challenges when selecting a jury of 12, 5 challenges when selecting a jury of 14, and 6 challenges when choosing a jury of 16 jurors. In addition, an attorney who perceives some irregularity in the selection of the entire veneer may submit a challenge to the array, sometimes called a motion to quash the array. If allowed by the court, the entire group must step down and a new set of prospective jurors is selected. The jury that has been formally selected and approved by attorneys for both sides is said to be impaneled. In some states, the judge selects one of the impaneled jurors to serve as the presiding member who will speak for the jury as a whole. The person is known as the foreperson. In other states, the foreperson is elected by members of the jury. The trial process. Once the jury is impaneled, the plaintiff's attorney delivers a speech known as the opening statement, which consists of a succinct outline of the allegations against the defendant and the evidence that will be introduced to prove each claim. More significantly, the opening statement must establish that the prosecution has put together a prima facie case, one that appears legally adequate to win a verdict in favor of the plaintiff. The Latin term prima facie means at first glance. All the oral proceedings in a trial are recorded by the court reporter, who either takes stenographic notes or uses specialized recording equipment. The notes or recordings become part of the official record of the case. They may be reviewed in typewritten form, known as transcript, by the jury or other interested parties. A note for the record. Note that the recording made by the court reporter isn't the same as the court report, which is an account of the court's decisions in a particular case. The court report is published together with a formal statement of the reasoning behind each decision, known as an opinion. The responsibility for establishing the truth is a legal dispute, known as the burden of proof. It usually falls into the plaintiff's counsel. Accordingly, after delivering an opening statement, plaintiff's counsel begins introducing evidence to prove the allegations in the pleadings and the opening statement. This presentation is commonly referred to as the case in chief. Courts distinguish between several different categories of evidence, outlined as follows. 1. Admissible evidence. Admissible evidence is considered pertinent and proper for reaching a decision. 2. Relevant evidence. Relevant evidence is introduced to prove or disprove a specifically alleged fact. 3. Testimonial evidence. Testimonial evidence refers to the oral testimony delivered under oath in open court. 4. Direct evidence. Direct evidence is testimonial evidence that describes something directly observed. 5. Circumstantial evidence. Circumstantial evidence consists of facts from which the occurrence of an event may be reasonably inferred. 6. Documentary evidence. Documentary evidence is confined to written materials such as contracts, affidavits, business records, wills, and so forth. 7. Real evidence. Real evidence, also known as demonstrative evidence, consists of actual objects such as photographs, clothing, weapons perceived to have a bearing on the case. An item introduced as documentary or real evidence is usually referred to as an exhibit. Each exhibit is usually referred to in alphabetical sequence. The first exhibit is introduced as Exhibit A, the second as Exhibit B, and so on. The case in chief begins with the plaintiff's attorney calling the plaintiff's first witness to the stand. In legal terms, a witness is someone who gives evidence involving direct observation or knowledge. Attorneys on both sides of a case may sometimes summon an expert witness, someone qualified by experience or training to render an informed opinion on a specific subject. The process of asking a witness questions in open court is referred to as examination. Attorneys examining witnesses they called are said to perform a direct examination. Attorneys performing direct examination must pose questions in such a way as to allow witnesses to respond in their own words. Such a question might be, "Tell us what happened on the afternoon of June 1st. Leading questions aimed at steering the witness into supplying a specifically desired answer aren't allowed during direct examination. Questions that require simple answers of yes or no are leading questions. An example of a leading question might be, "Isn't it true that just before the accident happened, you were looking down to put in a new CD?" Once the direct examination is concluded, the attorney for the defense may question the witness. Examination by opposing counsel is referred to as a cross-examination. Opposing attorneys are allowed to ask leading questions during cross-examination. If necessary, the prosecution may conduct a redirect examination to investigate issues raised during the cross-examination. Counsel for the defense may then follow up with a recross-examination. In general, all of the plaintiff's witnesses are examined in the same manner. It's not unusual for the opposing counsel to choose not to cross-examine a witness, in which case there would be no need for a redirect or recross-examination. After witnesses for the plaintiff have testified and the plaintiff's evidence has been submitted, plaintiff's counsel rests the case, that is, concludes the argument for the plaintiff. Once the plaintiff's counsel has rested, the attorney for the defense has the option of formally requesting the court to rule in favor of the defendant without giving the case to the jury. Such a request is known as a motion for a directed verdict. The motion may be granted if the judge determines that the plaintiff's evidence doesn't legally support a verdict in the plaintiff's favor. If the defense attorney does not move for a directed verdict, or if the court overrules the motion, counsel for the defense proceeds to make an opening statement. Counsel provides an overview of the defendant's case and describes in a general way the evidence to be presented. The defense then calls its witnesses and introduces whatever evidence may be necessary to support the claims made in the defendant's answer and in the counsel's opening statement. After the defendant's witnesses have been examined and cross-examined, and all supporting evidence has been introduced, counsel for the defense rests his or her case. At this time, the plaintiff's counsel has the option to offer a rebuttal, which is a formal introduction of evidence that will discredit or disprove the evidence introduced by the defense. After the rebuttal, either attorney may move for a directed verdict. At the close of the evidence, attorneys for both sides present a closing argument, orally summarizing the evidence in a way that favors their side of the case. The closing argument, also known as a summation, is delivered to the jury or, in the case of a bench trial, to the judge. The court typically allows 30 minutes for each side's summation. Once the attorneys have made their closing arguments, the attorneys for both sides provide the judge with the proposed jury instructions, their version of the law in that case. The judge then tells the jury what the law is in that particular case and how the law must be applied. This formal direction is known as a jury charge or jury instructions. When the jury deliberates or goes over the evidence and makes a decision, it is obliged to apply the laws as directed by the judge. This is the case in all statute courts and usually chancery courts. The outcome of the trial. At various points during the deliberation, the jury foreperson asked individual jurors for their decision. This process is known as polling the jury. In criminal cases, the jury must decide whether the prosecution has proved its case beyond a reasonable doubt, the highest degree of proof required by law. In other words, jurors must be fairly and logically and completely persuaded by the prosecutor's evidence that the defendant actually committed the crime as charged. The jury's decision is known as a verdict. In a criminal trial, the jury must agree unanimously on a verdict. A jury unable to agree is known as a hung jury or a deadlocked jury. In such cases, the judge must declare a mistrial, which is an invalid trial without legal consequences. The case may or may not be brought before the court again or retried, according to the decisions of the attorneys involved. By contrast, a civil jury decides a case based on the overall credibility or likelihood of the evidence presented by one side or another. This civil standard of proof is referred to as preponderance of the evidence. Moreover, only a clear majority of jurors in a civil trial must agree on a verdict. If the jury is deadlocked, the judge must declare a mistrial and the case may or may not be retried. Usually a jury is able to deliver a verdict. Afterwards, the court issues its formal decision in the case, commonly called a judgment or an adjudication. Depending on the proceedings, the court may issue one of several kinds of judgments, including 1. A judgment on the merits, based on the evidence and facts introduced, the most common result. 2. A judgment on the pleadings, issued without hearing evidence, should the court decide that the pleadings clearly and legally entitle one of the parties to win the case. And 3. A judgment notwithstanding the verdict, also known as a judgment non obstante verdicto, a GNOV, or judgment NOV, issued in favor of one party when the judge believes the jury's verdict in favor of the opposing party is incorrect. Of course, this would not be possible in a simple court of record, but this is possible in a statute court. The punishment imposed on a defendant found guilty in a criminal case is known as a sentence. In a civil suit, the financial penalty the defendant must pay the plaintiff is known as an award. An award may be enforced by a court order known as a writ of execution, ordering the sheriff's office or other enforcement agency to collect payment. Another type of collection requires a third party, such as an employer or a bank, to turn money or property owned by or owed to the defendant over to the court. The process is known as garnishing, and the third party is known as the garnishee. Of course, this is illegal if the defendant turns into a plaintiff and sues third parties for trespassing into their privacy and their legal rights. Appeals. After the court has issued its judgment, either litigant may petition another court to review the decision. Such a petition is known as an appeal. The litigant requesting the appeal is known as the appellant. The opposing party may be referred to either as the appellee, the respondent, or the defendant in error. A sum of money fixed by the court, an appeal bond, is often required to guarantee that the appeal is bona fide or legitimate. A court that hears the appeal is generally referred to as a higher court, in contrast with the court that originally heard the case, which is referred to as a lower court or sometimes the court below. At the state level, the higher court is called a court of appeals or an appellate court. In general, only questions regarding the application or interpretation of law, known as questions of law, can be raised in an appeal. Questions of law are decided by the court itself rather than a jury. A jury decides only questions relating to the activities that caused the litigants to seek a trial, referred to as questions of fact. An appeal court may occasionally allow appeals based on questions of fact if the jury has turned in a legally incorrect verdict which may be broken down into two categories. One, a verdict against the evidence, which either contradicts the evidence presented in the case or isn't adequately supported by such evidence. Two, a verdict contrary to law, which contradicts one or more points of the instructions given by the trial judge. Remember, this is only in statute law, and it cannot be applied in real and common law. A state may have one or more appellate courts at an intermediate level, known as superior courts or courts of appeals. In most states, the highest court, whose decisions are final unless there's a federal question, is known as the Supreme Court, or less formally as the High Court. In certain states, the highest court is called the Court of Appeals or Superior Courts. Within the federal court system, the intermediate appellate court is known as the Court of Appeals of the United States. The United States Court of Appeals is divided among 11 geographical regions or circuits. In addition to the 11 numbered circuit courts, the United States Court of Appeals includes 1. The United States Court of Appeals for the District of Columbia, or D.C. Circuit, which handles cases arising in Washington, District of Columbia. 2. The United States Court of Appeals for the Federal Circuit, which hears appeals on patent and copyright law, custom cases, and some lower court appeals. 3. The Court of Appeals for the Armed Forces, which hears appeals of court-martial verdicts. The highest court in the federal court system is the United States Supreme Court, which has both original and appellate jurisdiction. This means it can hear new trials as well as appeals from trials decided in other courts. The Supreme Court's original jurisdiction, however, is limited only to certain kinds of cases as specified in the United States Constitution. The federal circuit courts are divided among 12 geographical regions, first through 11 circuits and the D.C. Circuit, plus the Federal Circuit and the Court of Appeals for the Armed Forces. The First Circuit includes New Hampshire, Maine, Rhode Island, Massachusetts, and Puerto Rico. The Second Circuit includes Vermont, New York, Connecticut. The Third Circuit includes Pennsylvania, New Jersey, and Delaware. The Fourth Circuit includes West Virginia, Virginia, Maryland, North Carolina, South Carolina. The Fifth Circuit includes Texas, Louisiana, Mississippi. The Sixth Circuit includes Michigan, Ohio, Kentucky, Tennessee. The Seventh Circuit includes Wisconsin, Illinois, Indiana. The Eighth Circuit includes North Dakota, South Dakota, Nebraska, Minnesota, Iowa, Missouri, Arizona. The Ninth Circuit includes Washington, Montana, Oregon, Idaho, Nevada, California, Arizona. The 10th Circuit includes Wyoming, Utah, Colorado, Kansas, Oklahoma, New Mexico. The 11th Circuit, Alabama, Georgia, Florida. Also pertaining to the Ninth Circuit are Guam, Northern Mariana Islands, Alaska, and Hawaii. And the 12th Circuit is Washington, D.C., the D.C. Circuit, Federal Circuit. In order to be heard in an appellate court, the attorney for the appellant must complete all the appropriate steps required by state or federal statute. This process is known as perfecting the appeal. For example, in order to initiate an appeal, the attorney for the appellant must notify the appellee by filing a pleading known as a notice of appeal. Counsel for the appellee may file a pleading known as a cross appeal, setting forth a cause of action rising from the same judgment being appealed by the appellant. After the notice of appeal has been filed, attorneys for both sides must file a document known as a brief. A brief presents legal arguments supported by citations of various authorities such as previously published court rulings and scholarly journals. Where legal precedent isn't available, an attorney may support an argument using the comments a judge has made in a published opinion, known by the Latin term as a dicta. A precedent is a decision of courts in previous cases which other courts must rely upon when making decisions involving similar facts. A precedent is usually a common law fact. When referring to the dicta or the published opinion of a judge, such comments aren't considered legally binding. In support of their case, attorneys may occasionally file a brief written by a legal expert who isn't involved in the appeal. The person writing the brief is commonly referred to as an amicus curiae, a Latin term meaning friend of the court. Explaining the brief. The term brief has several legal meanings, depending on the context in which it is used. In an appeal, the term refers to a document summarizing legal points supported by various legal authorities known as points and authorities. A written summary of the legal points set forth in a published opinion is also known as a brief. An attorney preparing for a trial may wish to list the arguments, legal points, and questions to be covered in a document known as a trial brief. After deciding to hear an appeal, some state appellate courts issue a writ of certiorari in order to the lower court to certify and deliver the entire record of the case to the higher court for review. This includes all pleadings, transcripts, and judgments. When prepared for and sent to a higher court, this record is known as a transcript of the record, or a record on appeal. Many states have discontinued the practice, but the United States Supreme Court still issues a writ of certiorari when it decides to hear an appeal. When the court refuses an appeal, it denies issuing the writ of certiorari by writing the abbreviation cert-den, C-E-R-T.D-E-N. For certiorari denied. An appellate court that disagrees with the lower court's decision may invalidate the ruling. An appellate court that agrees with the lower court's ruling is said to affirm the decision. In such cases where a disagreement is found, the court is said to reverse, or set aside, or vacate the lower court's judgment. The appeals court may also remand the case, that is, send it back to the lower court for further proceedings. The new trial in the lower court is known as a trial de novo, and is tried again as though no prior decision had been made. We will now discuss tort law. Some wrongful actions, though perhaps not strictly criminal, may nevertheless inflict injury or loss on other people. In order to provide monetary relief to those who suffer losses from other people's actions, a special branch of law has been developed and refined. This branch is known as tort law, a term that comes from the French word tort, meaning wrong. Basic principles of tort law. Whereas a crime is considered to be a wrong against society as a whole, a tort is a wrong against an individual. A tort action is a civil action initiated by one party seeking financial compensation for losses or injuries caused by another party. The party accused of committing a tort is known as the tortfeasor. The act or actual deed causing injury or loss is known as a tortious act. Two or more people joining in a tortious act are referred to as joint tortfeasors. Certain wrongs, such as assault and battery, defined as a threat or harmful force carried out by physical contact, may be considered both a tort and a crime. In such cases, the state or federal government can initiate a criminal action with the intent of punishing the defendant. The party who sustains the loss or injury, or the party's survivors, can initiate a separate tort action against the defendant for the same act. Just as there are many different acts that may legally be considered crimes. Federal and state regulations define a wide variety of torts. Torts can be broken down into general categories, each of which includes specific torts characterized by their own particular details. All tort actions, however, are based on the following 4 points. Number 1, existence of a duty, defined in legal terms as an obligation imposed on the defendant by contract, court order, relationship, or common or statutory law. Second, fault, defined as a neglect or violation of a duty. Number 3, you have liability, defined as a causal connection between the plaintiff's injury and the defendant's fault. And number 4, you have damage, the loss or harm resulting from the injury. Liability is complicated because in most states, for example, people can't be held liable for refusing to help someone in distress. Exceptions to the rule may apply, however, as in the case of a lifeguard refusing to come to the aid of a drowning human being. Even so, the lifeguard may not be held liable if rescue was prohibited by certain conditions, such as an infestation of sharks. By contrast, people who handle a dangerous commodity, such as a gun, of course, guns are not dangerous in of themselves, but a bomb or a wild animal, legally referred to as a dangerous instrumentality, are always liable for injuries to others caused by the dangerous item. In such cases, the plaintiff does not need to demonstrate fault. Liability regardless of fault is commonly defined as absolute liability or strict liability. People responsible for wild animals are strictly liable for any injuries the animals may cause, which includes the destruction of property. Liability may be shared by more than one party. For example, the employer may be considered liable for a tortious act committed by an employee or other representatives. Liability for the act of another party in such cases is known as vicarious liability. Liability may also be shared jointly or severally by joint tortfeasors. Joint liability requires all joint tortfeasors to be named as defendants in a single tort action. Jointly liable tortfeasors must each pay a share, known as a contribution, of any damages awarded to the plaintiff. Several liability enables the plaintiff to sue each of the joint tortfeasors in a separate action, in which case each tortfeasor must pay the entire portion of damages awarded in the particular action brought against him or her. Legal exemption from liability is often referred to as privilege or immunity. Until quite recently, most charitable and government institutions weren't held legally responsible for tortious acts committed by their employees, agents, or representatives. The doctrine of charitable immunity, under which most charitable institutions were exempted from liability, has been abolished in most states under statute laws. The doctrine of sovereign immunity, under which a government agency is considered immune, which is really a doctrine that was applied to each and every people of the land, but has been interpreted as pertaining to only a few, which is error in such doctrine. But in each case, unless it agrees to be held liable, it has been abolished or diminished in most states. With a few exceptions, an act of Congress known as Federal Tort Claims Act has likewise abolished sovereign immunity at the federal level. Any judge, any legislator, any governor can be either sued or have his bond removed. Intentional torts. State and federal statutes define tortious acts that are committed deliberately as intentional or willful torts. In legal usage, the term intent refers to having a definite purpose in performing or refraining from a certain act. An intentional or willful injury is an injury caused by a person who knows the act will result in injury to another person. A willful and wanton act is an act understood as likely to cause injury and committed without concern for the consequences, particularly those which may endanger the lives or safety of others. Reckless driving and drunk driving stand out as examples of willful and wanton acts. In legal usage, the term reckless refers to a lack of concern similar to that implied by the term wanton. In legal usage, the term malice refers to a state of mind in which a person deliberately sets out to injure another person without cause and without regard to the legal rights of the injured party. An act deliberately intended to cause damage, loss, or pain and suffering of a person is therefore referred to as a malicious injury, or sometimes a willful and malicious injury. Bearing in mind the legal usage of terms such as intent and malice, let us take a more detailed look at some common intentional torts. Assault and battery. As mentioned earlier, assault is an act clearly and intentionally indicating a threat of physical harm. Verbal threats alone aren't classified under the law as assault. Battery is legally defined as an unjustified and intentional physical contact with another person without consent, that is, without agreement or permission. Aiming a weapon at someone, for example, may be considered an assault, while actually using the weapon to injure a person is considered battery. False imprisonment, sometimes referred to as a false arrest. False imprisonment is defined as deliberate confinement without legal justification. The injured party need not be physically restrained. Indications that physical force may be used to prevent the injured party from leaving is sufficient to constitute confinement. A storekeeper who detains a suspected shoplifter without reasonable grounds for doing so may be held liable for false imprisonment. Fraud, also referred to as deceit. The intentional tort or fraud involves the use of misrepresentation to induce another party to part with money or other valued property. The term misrepresentation here refers to a deliberate false or deceptive act or statement of material fact, an important fact without which an agreement would not have been made. Opinions or promises of events that might occur in the future aren't considered misrepresentations. Defamation, the willful use of false statements to damage another person's character or reputation, or to adversely affect a person's means of earning a living, is known as defamation. Examples of this tort may be divided into categories. 1. Libel. 2. Slander. First of all, libel is a type of defamation communicated through some sort of visual medium, such as writing, drawing, photography, or television or film. Slander is defamation communicated through a spoken word. Invasion of property. The right of property is legally defined as the right to be left alone. The right of property protects a person's private matters from unreasonable public interference. Violation of the right of privacy is referred to as an invasion of privacy, which may include such activities as follow. 1. Public circulation of a person's letters, diary, or other writings not intended for public communication. 2. Unauthorized use of a person's photograph for advertising purposes. 3. Listening in on or recording a person's private conversations. And 4. Unauthorized publication of personal information such as financial or medical records. Malicious prosecution. The tort of malicious prosecution arises when one party brings a suit against another party with malice and without probable cause. That is, without reasonable grounds for believing the allegations were true. Probable cause exists if something is more probable than not. In order to bring suit against the plaintiff or the plaintiff's counsel, the defendant in original suit must have been acquitted. The party bringing suit for malicious prosecution must also prove that charges had been brought maliciously and without probable cause. Trespass. Willful, unauthorized intrusion on real property, land or buildings and fixtures attached to land such as driveways, basketball courts, swimming pools, and the like that belong to another person and party is known as trespass. The owner of the property may bring an action for trespass regardless of whether any loss or damage has resulted from the trespass. Fixtures are also sometimes called improvements. Conversion. Unauthorized use or profit from someone else's real or private property is known as conversion. Examples of conversion include 1. Theft of property, 2. Failure to return borrowed property, 3. Unauthorized sale of another's property. Nuisance. Causing annoyance, inconvenience, or discomfort to another party through the use of your own property is called the tort of nuisance. Examples of nuisance include frequent or continuous loud noises, loud music, creating offensive odors, or causing unreasonable emissions of smoke. A nuisance that annoys or disturbs a wide range of people is called a public nuisance, whereas a disturbance affecting only one person or household is known as a private nuisance. Willful neglect. A deliberate and intentional failure to fulfill a legal duty toward another person is known as willful neglect. Most forms of child abuse are primarily examples of willful neglect. However, willful neglect may also include failure to provide for a spouse as required by law, or failure of a public official to perform a duty required by his or public office. Wrongful death. As you may recall, a wrongful act is an unlawful act or failure to act that results in damage to another person. In a civil action, a death that results from a wrongful act is referred to as a wrongful death. State statutes known as wrongful death statutes allow a personal representative of the deceased party to bring a lawsuit against the party accused of wrongful death, regardless of whether the defendant was tried or acquitted on criminal charges for the same act. A civil suit arising from wrongful death is known as a wrongful death action. Unintentional torts. While willful torts arise from acts committed by one or more people, unintentional torts typically involve some sort of failure to act in accordance with the law, commonly known as an omission. The most common type of unintentional tort is negligence, which is typically defined as a failure to act that results in injury to another person. The standard for determining negligence is known as a reasonable person test. The test essentially consists of asking what a person of ordinary intelligence and judgment, referred to as a reasonable person or a prudent person, would do in a specific set of circumstances. Negligence arises from a breach of duty, which is a failure to act in accordance with responsibilities defined by law. Civil law has established varying degrees of duty, which are in turn based on the level of care, that is, attention, caution, or safeguard appropriate to specific situations. Under the sudden emergency doctrine, the standard of degree of care required of a person caught unaware in an emergency situation is less than the degree of care ordinarily required if the person had time to think before acting. The varying degrees of negligence associated with specific degrees of care include the following. 1. Ordinary negligence. Defined as a failure of the degree of care known as ordinary care or reasonable care, which a person of ordinary intelligence and judgment would exercise under a specific set of circumstances and conditions. Number 2, negligence in law or negligence per se, defined as a failure to observe a duty or standard of care that has been established by law, such as the duty to stop at a stop sign, resulting directly in injury to another person. Number 3, willful negligence, defined as reckless indifference toward a person's safety, demonstrated by the failure to exercise ordinary care to prevent injury in the face of imminent danger. Number 4, gross negligence, defined as intentionally acting or failing to act with a deliberate disregard for the welfare of other people. Number 5, culpable negligence, defined as the willful and wanton creation of an unreasonable risk that will probably cause death or injury to another person. Number 6, negligent homicide, defined as causing death through negligent or reckless conduct that is demonstrably less intentional than the conduct involved in the tort of wrongful death. Many states have eliminated these varying degrees of negligence. instead holding property owners liable for exercising reasonable care toward anyone rightfully on their premise or rightfully using personal property. The duty of reasonable care does not normally extend to trespassers. The duty owed to a trespasser consists simply of refraining from willful, wanton, and reckless conduct. An exception to a legal duty owed to trespassers is established in situations involving an attractive nuisance, a structure, feature, or apparatus that possess a danger to young children, yet is sufficiently interesting to tempt them to trespass in order to examine or explore it. Examples of an attractive nuisance may include an empty mine shaft, an abandoned house, or an abandoned car or refrigerator. The attractive nuisance doctrine was established to protect young children by creating a duty for property owners to refrain from mere ordinary negligence, rather than willful, wanton, and reckless conduct toward children enticed to trespass by the presence of an attractive nuisance. This means that the landowner with an attractive nuisance must guard against both the lower standard of the willful, wanton, and reckless conduct, like covering a swimming pool with a tarp that collapses when stood upon, drowning the trespasser, to the higher standard of ordinary negligence, a swimming pool covered that would protect a trespasser but was improperly installed, leading to injury for the trespasser. In order to recover damages for negligence, the plaintiff must prove that actual loss has occurred. The plaintiff must also provide evidence that loss, harm, or pain and suffering was caused by the defendant's negligence. In certain situations, the plaintiff may lack sufficient evidence to prove that the defendant actually committed a negligent act. In such cases, the doctrine of res ipsa loquitur, a Latin term meaning the thing speaks for itself, can sometimes be used to prove that the plaintiff sustained injury by an act that normally would not occur unless someone were negligent. Under this doctrine, the simple fact that an act causing injury occurred can serve to show that the defendant was negligent. In addition to demonstrating damage and negligence, the plaintiff must also prove causation, that is, that the negligent act of the defendant was the direct or proximate cause of injury to the plaintiff. In determining proximate cause, the court asks whether the consequences arising from negligence could reasonably have been anticipated. Such consequences are typically referred to as foreseeable, and an injury arising from them is known as a foreseeable injury. Proximate cause is the legal cause of an injury, even though the injury may have had more than one cause. The court may deny damages because a reasonable person couldn't have foreseen loss or damage. In such cases, loss or damage is known as an unavoidable casualty or an unavoidable accident. A cause that couldn't have been avoided through reasonable or ordinary attention is known as an unavoidable cause. Similarly, damages may be denied if another event intervenes between the proximate cause and the act that results in loss or damage. Such an event is known as a supervening cause. For example, a car owner who leaves the keys in a car may be considered negligent and therefore liable if an injury arises from such negligence. However, if a thief steals the car and injures someone while driving negligently or fleeing from the police, the act of leaving the key in the car is replaced as proximate cause by the supervening cause of the thief's negligent driving. The injured party may therefore seek damages only from the car thief, not the car's owner. The defendant in a negligence suit may also offer defenses that reduce or eliminate liability for the plaintiff's injury. The common defenses are described as follows. 1. Assumption of risk. Assumption of risk, frequently offered in cases involving sports or recreational activities, holds that the injured party chose to enter into a situation or activity fully aware of the potential dangers involved. 2. Contributory negligence. Contributory negligence denies liability for all damages on the grounds that negligence on the part of the plaintiff contributed to the injury. A reckless or drunken driver, for example, may not be able to win damages from a driver who negligently ran a stop sign. The defense to contributory negligence may be denied in certain cases under a rule known as the last clear chance doctrine. Under this doctrine, a defendant who had the last clear chance to avoid injuring the plaintiff is liable even though the plaintiff was also negligent. Negligence under the last clear chance doctrine is sometimes referred to as supervening negligence. Number 3, comparative negligence is an alternative to contributory negligence and compares the negligence of both parties. Under this doctrine, the plaintiff's damages are reduced rather than denied. Damages are reduced in proportion to the level of plaintiff's negligence. Assumption of risk is often used as a defense against a negligence claim brought by someone who engages in dangerous activities. Product liability. Loss or damage caused by defective merchandise is known as a tort of product liability. In such cases, the injured party need not prove negligence. The defective product in itself represents a breach of warranty, a violation of the actual or implied promise of the product's fitness for a particular purpose known as a warranty. If the plaintiff can show that the product was sold in a defective condition, that it was unreasonably dangerous to the user or consumer, and that the defective condition was the proximate cause of injury, the manufacturer and seller are obliged to pay damages. Now let us look at criminal law. We learned that a legal action formally begins with filing a complaint, and that each defendant named in a complaint may offer one of several pleas to allegations listed in the complaint. We explored aspects of the pretrial and discovery processes, as well as procedures involved in trying criminal cases. Basic elements. Perhaps the most critical concept to grasp is the way in which crimes are legally defined. Whereas a tort is a violation of individual legal rights, an act that violates the law and legal rights shared by a community as a whole is known as a crime. Though a crime may specifically affect only one person, the act of breaking the law, often referred to as a violation, is considered an offense against the authority invested in the state or federal government. As defined by law, a crime consists of two essential elements. The first, known by the Latin term actus rea, is the criminal act itself. For example, the act of breaking into a home and stealing jewels is the actus rea of the crime known as burglary. The second element, known by the Latin term mens rea, is the intent to commit the crime. Mens rea, often used interchangeably with the term criminal intent, is frequently inferred or presumed from the criminal act itself. For example, the very act of breaking into a house and removing valuables is a fairly good indicator of the intention to steal. Mens rea is closely related to the term malice, which implies a wish to annoy or harm another person, or an intent to commit a wrongful act without regard to the lives or safety of other people. Criminal law describes several different kinds of malice. General malice refers to a generalized desire to commit harm or injury. Express malice refers to a specific plan to cause harm to a specific party. Malice aforethought, an important element in murder cases, refers to an intention to cause injury or commit a dangerous act prior to the act of killing. Contrary to the popular belief, the term does not imply a specific desire to kill. A person who commits a crime is known as a criminal. The term criminal appears in a wide variety of legal phrases. A crime, for example, may sometimes be referred to as a criminal offense. In any discussion of crime or criminal offenses, it's important to distinguish between similar terms. For instance, the entire branch of legal practice that involves defining, trying, and punishing crime is known as criminal law. By contrast, a specific law that defines a certain type of conduct as criminal and establishes the appropriate punishment for that crime is called the criminal statute. The entire published body of criminal statutes is called a penal code. The Commission on Uniform State Laws and the American Law Institute have worked together to propose a set of criminal statutes known as the Model Penal Code to serve as a model upon which state and federal legislatures may construct their own penal codes. Several other similar sounding terms must be approached with equal caution so as not to confuse them. The actual commission of a criminal offense, for example, is known as a criminal act. However, a lawsuit brought by the state or federal government against a criminal offender is known as a criminal action. A criminal action may also be called a criminal prosecution or a criminal proceeding, whereas the rules that describe the various steps involved in initiating and concluding a criminal action are known collectively as criminal procedure. A criminal action typically begins when a court issues a written order commanding law enforcement officials to detain or arrest the person named in the order and to bring that person before the court. Such an order is known as an arrest warrant. However, someone suspected of a crime may be arrested without a warrant if law enforcement agencies can show probable cause, that is, reasonable grounds for believing the person arrested committed the crime. When a police officer has a reasonable, articulable suspicion that a crime is afoot, such as spotting a person who matches the description of someone who recently robbed a nearby store, the officer may stop and question that person. A stop is when a person's freedom of movement or action is briefly inhibited. It is, in fact, and indeed, a form of arrest. Remember, articulable means that the officer can justify and explain the suspicion. This requirement is meant to prevent random stops and police harassment in the hopes of catching someone with contraband. A stop and frisk, also known as a Terry stop, is where an officer stops the suspect as above and performs a quick pat-down search for a weapon, which might be concealed on the suspect's person. The frisk may only occur if the officer has a reasonable, articulable suspicion that the person may be armed. There's no bright line, clear-cut, black and white definition of what constitutes a legal stop. Several Supreme Court cases address the issue. The officer has to do something that makes the person feel they can't just walk away, whether this is done by saying you're under arrest, or by grabbing the person, or by detaining the person and asking questions. The important thing to remember is that an officer may not constitutionally just walk up to an individual and stop them without a reasonable suspicion of wrongdoing. After a suspected criminal is arrested, the prosecutor, an elected public official who serves a specific jurisdiction and represents the government in a criminal court, must file a criminal complaint. The prosecutor is often known as the district attorney or the state's attorney. Federal prosecutors are appointed, not elected. The defendant named in the complaint is brought before the court for a preliminary hearing or probable cause hearing, which will determine whether sufficient evidence of criminal conduct exists. If probable cause is satisfactorily demonstrated, the judge may decide to confine the defendant in jail. Alternatively, the judge may decide to release the defendant in exchange for property or a sum of money commonly referred to as bail. Bail is used to prevent suspects from fleeing to avoid standing trial. Without having to keep every person suspected of a crime locked up in jail for months until their trial date, additionally, a judge normally has the authority to impose a defendant's bail any conditions that he or she believes necessary to preserve the public safety and ensure the defendant will show up for trial. If a suspect posts bail and does not show up for trial, the bail is forfeited and a warrant is issued for the suspect as a fugitive. After arrest, a suspected criminal may be held in jail until standing trial. In some instances, the court will release a person on his or own recognizance unless it appears that such a release will threaten the public safety or that the accused is likely not to appear at trial. Recognizance is a formal obligation that is recorded in court. in which the person gives the court a formal written statement acknowledging his or her obligation to show up for trial. The judge may impose non-financial reasonable conditions on someone seeking to be released on recognizance. If the accused on recognizance fails to show at trial, the accused will have to pay a monetary penalty, will have the recognizance revoked, and a warrant will be issued for the accused as a fugitive. The next step in a criminal proceeding depends on the seriousness of the crime committed. Criminal law has established three different categories of criminal offense. Number one, treason, defined as an act of war against the United States or giving aid and comfort to the country's enemies. Number two, felony, a serious criminal offense for which the punishment is more than 1 year of incarceration in a prison, a facility established specifically for people convicted of serious crimes or death. Note that although many laymen use words prison and jail interchangeably, for example, the killer was sentenced to 20 years in jail, in legal terms they are not the same thing. Then number three, misdemeanor, a less serious offense for which the punishment involves payment of a fine and or less than 1 year of incarceration in a jail, an institution usually local established specifically for people awaiting trial and for people convicted of less serious crimes.